Dear students, welcome to the live session. There was some technical issue, so it took some time. It was delayed for because of the technical issue. Now I guess it is audible and visible to all the students. Can you please give me the confirmation? Okay. As I already told, based on the request of the students who are following the channel, I have not only done the polity current affairs from the current affairs series. Today in the live session, we are also going to do 50 questions from all those topics. Now, keeping in mind the importance of the time, I am going to keep this session very short, but at the same time, it will be a session where the students will be able to cover up all the current affairs as well. Okay. So as I discussed, if you have any questions, you can put your questions also. I'll try to address your questions as well. Okay. So without taking much time, we'll quickly get into the questions. So 50 questions, I'll also let you know as to why these questions are important and what is the current affairs. So in this way, we'll try to cover all the 50 questions very quickly. Okay, so please come to the first question. Consider the following statements. This is a question related to the governor's power when it comes to giving the assent to the bills. We know that recently judgment has come from the Supreme Court of India, and what the judgment is all about. The judgment to some extent has given some directions as to what the governor can do whenever a bill is presented to him. And one of the important aspect of that particular judgment is the judgment has made it very clear that whenever a bill is sent to the governor from the legislature of the concerned state, and then subsequently the governor cannot sit on that bill for a too long period of time. If at all the ministers advise him to give the assent to the bill, he can just reserve that particular bill or keep it with him only for a period of 1 month. Within 1 month, he has to act on that particular bill. And suppose if the governor sends it for the reconsideration, and if he sends it for reconsideration, then when again the state legislature send it, within 1 month the governor has to give the assent to the bills. So therefore, the Supreme Court has given a very clear timeline and guideline as was what the governor is supposed to do whenever a bill is presented to him. And the Supreme Court made it very clear that the governor does not have any absolute veto with regard to the bills that is presented to him. And most importantly, the Supreme Court said that this power of the governor to give the assent to the bill is subject to judicial review. When I say it is subject to judicial review, that if the governor does not adhere to these timelines, then the judiciary can look into these matters. And another important thing is whenever the governor sends the bill for the reconsideration, subsequently when this bill is sent back to the governor again by the legislature, the governor has to give the assent within 1 month. Then he cannot again reserve it for the consideration of the president. Now all these important points has been given by the Supreme Court judgment. Presently, a latest development is that now the Supreme Court has been referred these matter by the President. The President has used his or her power under Article 143, and constitutional clarity is again sought. That is an issue that is still there, but as per the judgment, this is what is the case right now. So with that, just quickly come to the question. Governor can indefinitely sit on the bill reconsidered by the state legislature. No, the maximum time that the governor has got is only 1 month. So therefore, this particular statement is wrong. Governor's power regarding giving assent to the bills is subject to judicial review. Supreme Court made it very clear that it is now subject to judicial review if they don't adhere to the timelines. Governor hold office during the pleasure of the president. As per the Constitution of India, this is true. The governor even today holds office during what is called as a pleasure of the president. So how many of the statements given above are correct? So there are 2 statements which is correct. It is not asking which statement. Overall 2 statements are correct. So therefore the answer is option B. 2 only is the right answer. Please come to question number 2. This is related to the size of the Council of Ministers. Why this question has been asked related to the size of the Council of Ministers? Now I have brought in this particular question because after the 18th Lok Sabha is over, there was lot of news articles related to what shall be the size of the new government. So in that context, UPSC can ask you some question. So come to the first question. As per the Constitution of India, the size of the Council of Ministers in the Union shall not be more than 50% of the total membership of the Lok Sabha. This is definitely true because this 15% of the total strength of Lok Sabha was brought in by the 91st Constitutional Amendment Act in 2003. Now remember, this will not be a session where you will only cover the current affairs. We will also touch upon the conventional areas because most of the questions in the polity does come like this only. So therefore, this particular statement is definitely true. The Constitution classifies a Council of Ministers into Cabinet, Minister of State and Deputy Ministers. Today, this classification exists, there is no doubt. But this classification is nowhere mentioned in the Constitution. The Constitution does not make any of these classifications. It is only based on the transaction of business rules which is done by the President. So therefore, to say the Constitution classifies the ministers into these three types is definitely wrong. There is only one place, in fact, the word cabinet ministers are mentioned or ministers of cabinet rank is mentioned, which is in Article 352 of the Constitution. In no other place in the Constitution, nothing else is mentioned. So therefore, to say that all these things are there is definitely a wrong thing. So therefore, this particular statement is wrong. So which one of the statements given above are incorrect? So therefore, the incorrect statement is statement 1 is correct, statement 2 is incorrect. So therefore, the answer is option B, 2 only. So please come to the next question. Which of the following majority is required for the removal of the Vice President of India in the Rajya Sabha and Lok Sabha? Now, why this question has been chosen? For the first time in the history of India, in the Parliament, they try to move a motion to remove the Vice President. They try to move a motion against the removal of the present Vice President of India, who is also the Chairman of Rajya Sabha, Mr. Jagdeep Dhankar. So therefore, that was there in the news. So therefore, this could also be a very important question. So as per the Constitution of India, whenever the Vice President is to be removed, first a motion has to be introduced. And before introducing this motion, a 14 days notice has to be given to the Vice President. And if it is introduced in the House, then it has to be passed in that particular House. But in fact, you will have to remember this, as per the Constitution, such a motion can be introduced only in the Rajya Sabha, not in the Lok Sabha. And in the Rajya Sabha, it has to be passed with what is called as effective majority. And once passed by the Rajya Sabha, then it comes to Lok Sabha. In the Lok Sabha, it has to be passed with what is called as simple majority. So therefore, the answer here is what? In the respective houses. So in the Rajya Sabha, it should be effective majority. And in the Lok Sabha, it should be what is called as simple majority. And that is what is actually required. So it has to be very clear. So therefore, the answer here is what? The answer here is option C. C is the right answer. So therefore, not necessarily everything in the current affairs is directly asked, but the conventional areas out of that is the maximum chance that they can be asked. Okay, so please come to the next question. Which one of the following statement is not correct regarding the imposition of President rule under Article 356 of the Constitution? Now, why I have taken this particular question related to the President rule is because recently the state of Manipur was kept under the President rule. And whenever a state is kept under the President rule, it is done by virtue of the power that is given to the President under Article 356 of the Constitution. So please come to statement A. The President rule can be imposed by the President with or without the report of the Governor of the concerned state. So this is quite clear that we know that it is not necessary in all the cases that there should be a report from the Governor to impose a President rule. The President can do that either on the basis of the report from the Governor or otherwise also, whenever there is a constitutional breakdown in that particular state. So therefore, President rule can be imposed by the President with or without the report of the Governor. This is definitely true, but they are asking not correct. The President rule can be imposed only on the grounds of constitutional breakdown. So this is also true. The only condition as to on which the President rule can be imposed is on constitutional breakdown and not on the grounds of what is called as administrative breakdown. In fact, the Supreme Court has made it very clear in the SR Bommai case in 1994 also. The President rule imposed by the President requires a ratification by both houses of the Parliament by special majority. In fact, it does require a ratification from both the houses of the Parliament, but this ratification is not by what is called as special majority, but this ratification is by what is called as simple majority. So therefore, this is definitely wrong. The President rule can extend maximum up to a period of 3 years under certain conditions. Yes, normally the President rule can be extended up to a period of 1 year, but on certain conditions it may be also extended beyond a period of 1 year up to what is called as 3 years. All right. So just listen to the conversation, and if you have any questions, I'll try to take up the questions in between or somewhere in the end of the discussion. So therefore, what is the right answer here? The right answer is option C is the right answer. Now please to come to the next question. So consider the following statements regarding the cabinet committees in India. Statement 1. Normally, if the Prime Minister is part of the cabinet committee, why this is again relevant is, after the 18th Lok Sabha elections, after the new government is formed, a lot of cabinet committees were created. And this cabinet committees that is created in our country is also based on what is called as a transaction of business rules. None of these cabinet committees find mention in the constitution. But as a principle in our country, in all the cabinet committees, the Prime Minister may be part of it. There may be certain exceptions where the cabinet committee may not consist of the Prime Minister also, but mostly he is part of all the cabinet committees. He is not only part of all the cabinet committees, wherever he is part of a cabinet committee, he himself will chair that particular cabinet committee. Now, what is basically a cabinet committee? A cabinet committee is a system where all the important ministers will be there of cabinet rank. Therefore, the decisions are taken collectively by having discussions. So, for example, recently India was having airstrikes against Pakistan. So, that was decided based on a cabinet committee. So, important decisions of the government will be decided by what is called as cabinet committee. Now, normally if the Prime Minister is part of the cabinet committee, he or she heads the committee. That is definitely true. So, it is only the Prime Minister who will head the committee. Only the ministers can take part of the only the ministers can take part in the cabinet committee meetings. So, is it only the ministers? No. Apart from the ministers, others experts can also be called upon by the Prime Minister. So, normally it is not necessary only the cabinet ministers are there. Sometimes certain experts may also be called upon. Say for example, the National Security Advisor may be called upon, or any of the other experts may be called upon. So, this is basically only to say the minister is part of it, that is wrong. So, therefore, this particular statement is wrong. Which of the statements given above are incorrect? If you see which of the statements given above are incorrect, so therefore, the statement incorrect is 2 only. Statement 2 is incorrect. So, please come to next question. As per the Constitution of India, a serving Chief Minister. Why this particular question? Can a serving Chief Minister be prosecuted in a court of law? That is very much possible, because recently the Chief Minister of Karnataka was to be prosecuted by the law enforcement authorities on the basis of what is called as Prevention of Corruption Act, for which the Governor of Karnataka has given the permission. So, this was there in the newspaper. That is why I have brought in this particular question. As per the Constitution of India, a serving Chief Minister of a state cannot be prosecuted in criminal cases as they enjoy immunity under the Constitution. When you say they cannot be prosecuted, this is definitely wrong. The Constitution does not give any immunity to any Chief Ministers in the country. So, recently, as I already said, that the Governor of Karnataka has given permission to prosecute the Chief Minister under the Prevention of Corruption Act. But however, the only thing that you have to keep in your mind is, if at all any Chief Minister or any minister is to be prosecuted under the Prevention of Corruption Act, the prosecuting authority should take permission from the competent authority as per the Prevention of Corruption Act, and the competent authority in this case is nothing but the governor of that particular state. So, therefore, this statement definitely is wrong. A serving Chief Minister can be prosecuted for corrupt activities under the Prevention of Corruption Act within the approval of the governor of the concerned state. So, this is definitely true. So, based on the approval of the governor of the concerned state, it can be done. Which of the statements given above are correct? So, the correct statement is option B only. So, 2 only is the right answer. So, come to the next question. Consider the following. Who among them has got immunity under Article 361? Constitutional immunity under Article 361 of the Constitution. Why this particular question? There was a case of sexual harassment that was filed against the governor of Bengal, and which is still in the court. So, the court has asked certain opinion as to what extent the governor shall exercise immunity. So, therefore, this question also becomes very important. If you see Article 361 of the Constitution, Article 361 of the Constitution gives immunity to 2 constitutional authorities under the Constitution of India. One is the governor under Article 361 and also the president under Article 361 of the Constitution. In both the cases, no criminal cases can be brought in against them during their term of office. It is not that there will not be any criminal cases at all, but during the term of office, there cannot be any criminal offences or charges that can be taken up and they can be subject to prosecution. So this immunity is given under Article 361. So this immunity is given only to the president and to the governor. So not to the vice president or to the speaker of the Lok Sabha. So how many of the above authorities enjoy the constitutional protection? It is only option B, that is 2 only, because of the president and the governor given immunity under Article 361. The term spoil system recently reported in the news related to what is a spoil system, why this is related to the current affairs. Spoil system is a kind of system that is followed for appointment to higher levels of civil servant in United States of America. Now why this is there? Because recently the government has withdrawn certain lateral entry notification. The government came out with certain lateral entry notifications in our country, and subsequently the government for some reason has withdrawn this lateral entry notification. So at the time a lot of news articles has come and there was some element of assessment of this lateral entry. Now based on the newspaper reports, one of the criticism of the lateral entry that happens in India is some of the experts have suggested that the lateral entry may lead to what is called a spoil system. So spoil system is something what? Spoil system is a system followed in United States of America in appointing the higher levels of officials in the government, not on the basis of merit but on the basis of the liking by the president. So whomever the president like, he may appoint someone as the top positions in the government. So this is basically referred to as to what is called a spoil system, which is against the principle of merit. So therefore one element of criticism, so it doesn't mean that nothing is correct with the lateral entry, because the lateral entry system of recruitment in itself has got lot of advantages. But as per the news reports, as per the criticism is that the lateral entry can also turn out to be a spoil system if there are no proper checks and balances. So with that, if you see what is the answer for this particular question, the term spoil system recently reported in the news is related to what? Corruption in administrative system, no. System of appointment to the civil servants in the higher levels of the government, appointment of judges in the higher judiciary, none of the above is also wrong. So therefore the right answer here is option B is the right answer. Please come to the next thing. Consider the following statements regarding the leader of opposition in the Lok Sabha. Why this question on leader of opposition in the Lok Sabha? Because in the 18th Lok Sabha we have got what is called as the leader of opposition. Before this 18th Lok Sabha there was no leader of opposition in the 16th Lok Sabha also, in the 17th Lok Sabha also. That means for the last 10 years there was no leader of opposition before the 18th Lok Sabha, and right now we have got what is called as a leader of opposition. So therefore the questions are likely to come in the examination, so that is why we are covering this particular question. The leader of opposition is given a statutory recognition in our country. Yes, of course the leader of opposition was initially not given statutory recognition, but the Salary Allowances of Leader of Opposition Act 1977 that has given a statutory status to the leader of opposition today. And the leader of opposition today exercise and enjoy similar benefit as that of a cabinet minister, although he is not a cabinet minister. So this is definitely true. The minimum strength of party that possesses to have a leader of opposition is to have 100 in the Lok Sabha and 50 in the Rajya Sabha. In fact, this leader of opposition is there in both the houses of the parliament, both in Lok Sabha as well as Rajya Sabha. But as per the conventional practice, to recognize someone as a leader of opposition from the opposition party, that party should have a minimum of 1/10 of the strength of that particular house. So it is not fixed 100 in Lok Sabha and 50 in Rajya Sabha. No, it may be for other reasons, but when it comes to leader of opposition, they shall not have less than 1/10 of the strength in the Lok Sabha and Rajya Sabha. So therefore this is wrong. So which of the statements given above are correct? So the correct statement is option A, that is 1 only is the right answer. If you know the answer, you can put it in the comment box. So who is the leader of opposition in the Lok Sabha today? And also the name of the person who is the leader of opposition in the Rajya Sabha today. Okay. So both of them are from the Congress party, but if you know the name, you can put the name of the leader of opposition. So come to the next question. Consider the following statements regarding the pro-term speaker. Now why this question on pro-term speaker? Again, after the 18th Lok Sabha, during the appointment of the speaker pro-term, there was a lot of controversy between the government, that is the ruling party, and the opposition party. The opposition party claimed that the conventional practice has been violated. So in this context, a lot of news article came with regard to as to the speaker pro-tem. Now the speaker pro-tem office is nowhere mentioned in the constitution. It is only a conventional practice today in our country that the senior most member of the house in the Lok Sabha is appointed as a speaker pro tem. After the Lok Sabha session comes into existence, normally the senior most member of the house is appointed as a speaker pro tem, and he is appointed by the president of India. So he is not elected, he is appointed by the president of India. And as I said, he senior most member. When I say senior most member, not in terms of their age, but in terms of how many times they got elected to the house. So there was controversy between both the ruling party and the opposition party, and that's why this was reported in the newspaper. But however, what is the purpose as to why the speaker pro tem is appointed? This purpose as to why the speaker pro tem is appointed today is, it is a speaker pro tem who will conduct the election of the speaker. Because the speaker has to be elected, and as per the constitution, the speaker has to be elected as soon as possible. So the speaker has to be elected, but who will conduct the election of the speaker? It will be done by the speaker pro tem on a date that is decided by the president of India. So the date will be decided by president, the election will be conducted by the speaker pro tem, and once a regular speaker is elected, then the office of the speaker pro tem cease to exist. Then therefore there is no more need of the speaker pro tem. So come to the question here. The pro tem speaker is appointed by the president of India. This is definitely true. As a conventional practice, usually the senior most member of the house from the Lok Sabha in the opposition party is appointed as a speaker pro tem. No, it is only a conventional practice. The senior most member is appointed as a speaker pro tem, not from the opposition party. The speaker pro tem decides the date on which the election of the speaker is to be conducted. No, the speaker pro tem will conduct the election, but the date will be decided by the president of India. So how many of the statements given above are incorrect? So if you see, 2 statements are incorrect. So therefore the answer is B, that is 2 only. So please come to the question number 11. Consider the following statements regarding the post of speaker in India. So why again it is important this year? Because it has not happened every time that once the Lok Sabha election is over, that there is an election to the post of the speaker. In fact, do you know that in the entire constitutional history of India, only 3 times the election to the speaker has happened before the 18th Lok Sabha. And if you see in the 18th Lok Sabha, the Congress party, which also become the major opposition party, they said that they are also going to field a candidate to contest election for the post of speaker. Because the only thing that is given in the constitution as to who can become the speaker is that he or she should be a member of that particular house. The constitution does not say anything that the speaker has to be from the ruling party or from the opposition party. He or she should be a member of that particular house, and anybody who is a member of Lok Sabha can contest election to the office of the speaker, and they have to be elected by the simple majority. So therefore it is a conventional practice that from the opposition party nobody will field to contest election to the post of the speaker, because obviously that they know that they do not have the majority. But when there is a close tie in terms of, when there is a close competition in terms of numbers between both the ruling and the opposition party, sometimes opposition parties may also field a candidate for the post of speaker. And this time the Congress and the India Alliance was saying that they are going to field the candidate for the election to the post of speaker. Therefore, a lot of news has happened, although the elections have not happened, and Mr. Om Birla was elected unopposed. Finally, there was a compromise. So it is not necessary the election has to be there. But if an opposing candidate is also contesting the election, then the elections are likely to happen. Otherwise, the speaker will be elected unopposed. Now come to the question. As per the constitution, the speaker must be elected within 6 months from the date of summoning the first session. So there is no fixed timeline that is given in the constitution. The constitution only says that once the new session comes into existence, after the Lok Sabha election is over, once the session is summoned, as soon as possible, both the speaker and the deputy speaker is to be elected. To say that it is within 6 months is wrong. The actual conduct of election of the speaker is mandatory even if there is no contest from the opposition party due to lack of majority. The actual conduct of election of the speaker is mandatory even if there is no contest from the opposition party due to lack of majority. Now try to understand that the actual election is not mandatory. When the election to the post of speaker becomes mandatory is only when the opposition parties also field a candidate. Otherwise, the speaker may be elected unopposed also. So therefore, to say elections are mandatory is not the right thing. So which of the statements given above are correct? So the statements that would be correct here is both the statements are incorrect. So therefore, here it is asking how many statements are correct. So therefore the answer is option D, that is neither 1 nor 2. Is the speaker to be elected? Yes, the speaker has to be elected, but the conduct of election, is it mandatory? That is not mandatory, because when the opposition is not having the majority in the first place, why to conduct the election? A candidate may be elected unopposed also. So this is basically, you should understand. This question is related to the powers of the speaker, because there was controversy surrounding the election of the speaker. A lot of news articles have also come describing about the various powers of the speaker under the parliamentary democracy in our country. So therefore this question also becomes important. So what are the powers of the speaker? How many of the above powers are exercised by the speaker Lok Sabha? Power to expunge the speeches considered to be unparliamentary. What do you mean by the power to expunge? Whatever is spoken in the houses of the parliament, they are recorded in verbatim. Actually, it is all recorded in the house, but will all be available for the future generations to consume it, that is to read about it? No, it is subject to the expunging powers of the presiding officer. The presiding officer might expunge some of the content. When I say expunge some of the content, the presiding officer may remove some of the content. So that is definitely possible as per the constitution and also as per the rules of the house, which I will discuss in detail when I take up the parliamentary privileges in the next question. So therefore this is definitely a power. It is also the power of the speaker to certify a bill as a money bill. Yes, this the speaker can do under article 110 of the constitution. In fact, it is a speaker who is the only authority to certify what is called as a money bill. Disqualify members on the grounds of anti-defection law. So this is also the power of the speaker as per the 10th schedule of the constitution. Preside over the joint sitting. Yes, if at all a joint sitting is convened by the President of India. So who can convene a joint sitting? It is only the President who can convene a joint sitting. If the President convenes a joint sitting, then it can be presided by the speaker. So this is also definitely true. How many of the above are the powers exercised by the speaker? So 4 only. All the 4 things that is given here are all powers exercised by the speaker. So therefore the answer is option D. All these questions are based on the current affairs. Although some of the areas are related to conventional areas, in UPSC also, if a current affairs happens, not necessarily the question will come only from those areas. They can ask from the related current affairs also. So you should keep this in your mind. Come to the next question. Consider the following: defamatory, indecent, unparliamentary or undignified. Which of the above shall be the grounds on which the presiding officers can allow for expunging of speeches in the parliament? So which of the above shall be the grounds on which the presiding officer can allow for expunging of the speeches in the parliament? First of all, we should know what is expunging. Expunging means the removal of certain content from what is spoken in the parliament. That's basically what is called as expunging. Now before I go to this particular question, you'll have to understand as to what is called as parliamentary privileges. As per article 105 of the constitution, there are certain privileges that is given to the members of the parliament. But before I discuss that, why this question is relevant? Recently, the speaker of Lok Sabha and also the chairman of Rajya Sabha, they have expunged a number of statements which is done, especially by the leader of opposition. Leader of opposition, Mr. Rahul Gandhi, has been critical of the government and the other members when he was speaking in the parliament. So some of his speeches were expunged. So the argument here is whether it is right or wrong is not for us to decide, but the point here is you will have to understand as to what is expunging when it comes to the examination, for which we will have to go to article 105 of the constitution, which provides for what is called as parliamentary privileges to the members of the parliament. So what are these parliamentary privileges? If you see, there are 2 explicit privileges which is given in the constitution. One is the right to freedom of speech. Second is that the members shall also publish the proceedings in the houses of the parliament. That means they can publish whatever has happened in the houses of the parliament, but the right to publish also includes what is called as expunging by the presiding officers. That means the members have the right to publish the proceedings. Proceeding means whatever discussed in the houses of the parliament, subject to what is not expunged. If something what is discussed in the houses of the parliament, if it is expunged, that means if it is removed by the speaker, then those portions cannot be published outside. Therefore, the constitution indirectly gives this power to the presiding officer, both to the Lok Sabha as well as Rajya Sabha, to expunge certain things. Expunge means to remove certain contents, because inside the house the members have a lot of privileges, but not everything that is spoken may be true. Something may be false, something can be misleading also. So therefore, it is better that these contents are removed from the official records, and that's basically what is called as expunging. But however, the constitution does not say what is the ground on which the contents may be expunged. So these are all regulated by the rules of Lok Sabha and Rajya Sabha. As per the rules of Lok Sabha and Rajya Sabha, if you see usually what are the grounds on which certain speeches may be expunged, a portion of a speech may be expunged by the presiding officer. If it is defamatory in nature, that is definitely true. If it is defaming the other individuals, if it is indecent in character, and also if it is unparliamentary and undignified in nature. So all these things are allowed as per the rules of the house. So therefore, what is the answer? Which of the above shall be the grounds? All of the above. So option D is the right answer. In fact, this was also there in the current affairs, very, very important. So please come to the next question. Consider the following statements. Why this is important? Because today there is a petition that is pending in the Supreme Court related to what is called as money bill, or what is the ground on which to decide whether a bill is a money bill or not. So this matter is still pending in the Supreme Court. So therefore this question becomes very important. Otherwise also every year there is a question on money bill. So these are all very, very important areas. So come to the question. Article 110 of the Constitution deals with the procedure of a money bill. So yes, is it Article 110? Article 110 is there, which is related to the money bill, but Article 110 does not deal with what is called as a procedure for a money bill. Article 110 only deals with what is called as a subject matter of the money bill, as to what can be seen as subject matter. In fact, there are 6 subject matter which is directly given under Article 110, and there is also the 7th matter which is incidental, which is related to all these 6 matters. So therefore, this is only related to what is called as subject matter. Article 109 of the Constitution deals with the subject matter of the money bill. Article 109 of the Constitution does not deal with the subject matter. Article 109 of the Constitution deals with what is called as a procedure for a money bill. So which of the statements given above are incorrect? When you say incorrect, in fact both the statements are incorrect. So therefore the right answer is option C. But apart from that, as a student preparing for UPSC, you should also know other things also. Where the bill can be introduced, does it require the prior recommendation of the president? What is the power in the hands of Rajya Sabha when it comes to money bill? From any of these areas, the questions may be asked. Okay, so it is very, very important for you to look into all these things. So please quickly come to the next area. Consider the following statements regarding the Public Accounts Committee. So why this question is also very important when it comes to Public Accounts Committee? Now this question becomes very important because recently the Public Accounts Committee said that they are going to review a lot of regulatory bodies in our country, including the Security Exchange Board of India. So in this context, UPSC may focus upon what is called as a Public Accounts Committee. And we know that the Public Accounts Committee today is one of the financial committees. So in addition to the Public Accounts Committee, we have other committees also. We have Estimates Committee, we have Committee on Public Sector Undertaking. All the 3 committees are important. Any of these committees can be asked for the examination. And among this, the largest financial committee is the Estimates Committee. It has got 30 members. But the Public Accounts Committee also plays a very significant role. And if you see the Public Accounts Committee has got 22 members, out of which 7 members come from Rajya Sabha, 15 members from Lok Sabha. All the members are elected by proportional representation means, and every member is elected for a period of 1 year. No minister can be a member of this particular house. All these things are we know, but there are few more information that was reported in the newspaper. So look into the first statement. The Public Accounts Committee is one of the oldest parliamentary committees that has its roots in the Financial Committee established in 1921 following the Montagu-Chelmsford reforms. We know that the Montagu-Chelmsford reform is in the nature of constitutional development during the Crown rule in our country. Montagu-Chelmsford reform 1919. In fact, the Montagu-Chelmsford reform advocated that, and based on which then they brought in what is called as a similar form of committee, that is Public Accounts Committee. So therefore, this particular statement is factually right. Come to the second statement. The PAC consists of 22 members, all nominated by the respective presiding officers of the House. So 22 members is true, but when you say that all nominated by the respective presiding officer is wrong, because the members of the Public Accounts Committee is elected from among the members of the House. 15 members elected from Lok Sabha, 7 members elected from the Rajya Sabha, based on the method of proportional representation by means of single transfer vote. So therefore, to say all nominated is wrong. So which of the statements given above are correct? So the correct statement is A only. 1 only is the right answer. So please come to the next question. Consider the following statements regarding the Because by the 104th Constitutional Amendment Act, the nomination that can be done to the Anglo-Indian has been done away with. And after that, today, there is a lot of protests that is happening that the Anglo-Indian community members are again demanding that particular provision. Therefore, it was there in the newspaper. In this context, it becomes relevant for your examination also. The first statement is the term Anglo-Indian is not defined in the Constitution. To say that the term Anglo-Indian is not defined in the Constitution is wrong, because the term Anglo-Indian is very well defined in the Constitution, and it is defined in Article 366 of the Constitution. So, where it is defined? It is defined in Article 366. So, therefore, to say not defined is wrong. The 104th Constitutional Amendment Act has not given any extension to Anglo-Indian nomination in the Lok Sabha post 2020. So, after the year 2020, this is true. In fact, in the original Constitution, it was provided that the President can nominate 2 members from the Anglo-Indian community in the Lok Sabha. But however, this was only for the first 10 years. But after every 10 years, a constitutional amendment was brought in and the extension was given by another 10 years. But in the year 2020, by the 104th Constitutional Amendment Act, this extension was not extended further. So, therefore, this particular statement is true. So, which of the statements given above are correct? So, the correct statement is statement 1 is wrong, statement 2 is correct. So, therefore, the answer is option B. Alright, so please come to question number 17. So, this year again delimitation is a very important topic, because there is a lot of southern states in our country, they are opposed to what is called as delimitation. There is a lot of issues that is happening with regard to delimitation. In general, what do you mean by delimitation? Delimitation is a process by which the number of seats to the Lok Sabha and to the legislative assemblies in every state will be decided. It is not only about deciding the number of seats or number of constituencies from every state as well as in the Lok Sabha elections. It is also about redrawing the boundaries of these constituencies, or as to what shall be the boundaries. Now, only when this information is there, the Election Commission of India can carry out the election. For this particular process, the Constitution says that there shall be a delimitation exercise before every election, and that delimitation shall be done by a specific authority which is created by an act of parliament. Accordingly, for the first time, the parliament enacted the Delimitation Act 1952, and they created what is called as a Delimitation Commission to do this. So, therefore, the Delimitation Commission today in India is a statutory body. It is not a constitutional body, it is a statutory body. But however, the powers that is given upon this Delimitation Commission is so vast that generally that whatever is the decision that is taken by the Delimitation Commission shall not be subject to what is called as judicial review. But there may be exception to this, but the general principle is they are not subject to judicial review. So, with that information, let us go and let us try to decide this particular question. The delimitation exercise in India is carried out by the Delimitation Commission, which is a constitutional body. So, it is not a constitutional body, rather it is a statutory body. So, therefore, this is wrong. Come to statement number 2. Presently, the delimitation is done on the 1971 census, on the basis of 1971 census, when it comes to determination of number of seats in the Lok Sabha from various states and union territories. So, this is definitely true. So, this 1971 census is likely to continue till the first census is published. So, till what point of time this 1971 census is likely to continue? Till the first census is published post 2026. So, whenever the first census will be published post the year 2026, it is based on the 1971 census. In fact, this is the issue that some of the southern states are having. The southern states feel if the next delimitation is carried out based on the latest census after 2026, then they may tend to lose, because it is not on the 1971 census, because the southern states went on reducing the population, but whereas on the other hand, the northern states and certain other states went on increasing the population. So, therefore, the southern states fear is that they may lose out on the number of seats, and that is why the issues that is happening, and therefore, it also becomes relevant for the examination, and the students preparing for UPSC, you should focus on these developments. So, which of the statements given above are correct? So, the correct statement is, anyway, statement 1 is wrong. Presently, the delimitation is done based on 1971 census. That is true. As long as the first census after 2026 is published, the delimitation exercise will be based on the 1971 census. So, this is definitely true. So, which of the statements given above are correct? So, the correct statement is B only, that is 2 only is the right answer. Alright, so please come to the next question. Consider the following statements regarding motion of thanks in the parliament. Why this motion of thanks becomes very important? Because during the budget session this year, there was a motion of thanks for the presidential address. In fact, every budget session, that is every first session of a year, and also first session after the general election, the president makes what is called as a formal speech in the houses of the parliament, a conventional speech in the houses of the parliament, which is basically what is called as a presidential address. This address is basically the agenda. The president comes and read the agenda of the government, whatever is prepared by the government. After the speech is over, after the presidential address is over, to thank the president for making such a speech, a motion of thanks is introduced. In fact, the motion of thanks is introduced in both the houses of the parliament. This year also it has happened. In fact, every year it will happen. So therefore, every year there is a chance that they can ask this. After the motion of thanks is introduced in the both the houses, it will be discussed and it will be put to vote in both the houses. But if the motion of thanks is not passed in the Rajya Sabha, it is not a big deal for the government. But if the motion of thanks is not passed in the Lok Sabha, it is automatically considered to be a no confidence motion against the government. So therefore, it is very important that the motion of thanks is passed in the Lok Sabha by simple majority. Otherwise, it is assumed that the government is not having the majority in the Lok Sabha. So this is very, very important. So now come here, with that come to this particular question. There is no mention of the word motion of thanks in the constitution. Of course, this is true. There is no mention of word motion of thanks. It is only what is called as a conventional practice. And in fact, the exact word motion of thanks is not mentioned, but we are following it. The motion of thanks can be introduced only in the Lok Sabha. In fact, the motion of thanks is introduced in both the houses of the parliament. But if it is not passed in the Lok Sabha, then that would amount to defeat of the government. So therefore, to say that it can be introduced only in the Lok Sabha is wrong. If the motion of thanks is not passed in both the houses in the Lok Sabha, it is automatically deemed as a no confidence motion against the government. So therefore, this is true. So choose a correct answer from the quotes given below. So what is the correct? Okay, there is no mention of word no confidence. Sorry, there is no mention of the word motion of thanks. So statement 1 is correct. So make a small correction. But the motion of thanks can be introduced only in the Lok Sabha is wrong. Choose a correct answer from the quotes given below. So the correct answer is 1 and 3 only. So what is the answer here? Option A, that is 1 and 3 only. So I am sure that till this point of time it is clear to the students. So come to the next question, that is question number 19. Consider the following statements. The process of appointing the Chief Justice. We know that why this is important. Recently, the 51st Chief Justice of India was appointed. By the time I am making this live video, already the 52nd Chief Justice is also appointed. But the question for UPSC would have already been set. So we will just look into the 51st Chief Justice. So therefore, you should understand certain things about the Chief Justice of India. The process of appointing the Chief Justice of India is mentioned in the Constitution. Is it mentioned in the Constitution? The process for appointing the Chief Justice of India is not mentioned in the Constitution. In fact, there is nothing specifically mentioned for the appointment of Chief Justice of India. The Constitution only talks about appointing the judges of the Supreme Court. In fact, the Chief Justice is also judge of a Supreme Court. But however, is it specifically something mentioned in the Constitution about the appointment of Chief Justice? No. Presently, we follow only a convention. What is a convention? The convention is the outgoing Chief Justice of India would recommend the name of the senior most judge to be appointed as the next Chief Justice of India. So this is a conventional practice, but there is nothing which is specifically mentioned in the Constitution. So the process of appointing the Chief Justice of India is mentioned in the Constitution is wrong. Justice Khanna, who succeeded Justice D.O. Chandrachud as the Chief Justice of India, is the 51st Chief Justice to occupy the office. This is true. But presently we have now Mr. B.R. Gavai, Justice B.R. Gavai. So who is the 52nd Chief Justice? But I think that happened just before 4-5 days. So therefore, very unlikely to be asked in UPSC. But yes, the 51st Chief Justice has happened 4-5 months earlier. So therefore, it may be asked. So therefore, the answer here is, even if you don't remember the facts, at least you should know that the procedure is not mentioned in the Constitution. So this is definitely true. So which of the statements given above are incorrect? So the incorrect is again statement 1 only, that is option A only is the right answer. Please come to the next question. Consider the following statements. The Supreme Court has a power to take up suo motu cognizance of any matter. Does the Supreme Court has a power to take up suo motu cognizance of any matter? In fact, they do have. Now, why I brought this particular question to your notice? I brought this particular question to your notice because recently an order was passed by Lokpal. and wherein in that particular order, the Lokpal order said that the judges of the High Court will be considered to be public servants under the Lokpal Act, and therefore the Lokpal will have jurisdiction over the High Court judges. Because as per the verdict that was passed by the Lokpal, they said that the judges in the High Court are considered to be public servants within the definition of Lokpal, and the Lokpal will have jurisdiction over all the public servants. But however, this order which was passed by the Lokpal, which was subsequently stayed by the Supreme Court, and in fact the Supreme Court of India has taken suo moto cognizance in this particular matter. When I say suo moto cognizance, they themselves have taken up this particular matter. That's basically what is called as suo moto cognizance. So therefore, to say that the Supreme Court has a power to take up suo moto cognizance on any matter, this is definitely true. That's the power of the Supreme Court. As per the Supreme Court of India, the judges of the High Court shall fall within the definition of public servant under the Lokpal Act 2013. Now, this was not held by the Supreme Court, this was held by the Lokpal, where they said that the judges would be considered to be what is called as public servants within the definition of the Lokpal Act, which the Supreme Court has stated right now. So, the Supreme Court has stated where the Lokpal has held has given this particular judgment. Which of the statements given above are correct? So, the statement that would be correct is 1 only, that is option 1 only. So, these are all very, very important area for your examination. Alright, so with that I will move to the question number 21. So, before I move to the question number 21, let me also see that if there is any doubt from the students. Okay, if you have any doubts, you can just put it in the comment box also, so that I can just look into it. I could see Ruby, I could see Kabir, I could see Marvi. So, if you have any other questions, you can just put it in the comment box. Okay. Alright. So, with that, you please come to the next question. Question number 21. Consider the following. Proved misbehavior, incapacity, violation of the constitution, office of profit. How many of the above grounds are mentioned in the constitution for the removal of the judges of Supreme Court and High Court? Why this removal of judges of the Supreme Court is important? Recently, the government has tried to, the opposition members have tried to bring in a motion with regard to removal of a judge of the Allahabad High Court. And not only the judge of the Allahabad High Court, so recently there is issue happening with one of the sitting judge in the Delhi High Court also. So therefore, lot of controversies are happening with regard to the judges. So therefore, this area is also very, very important. Now, can the judges of the High Court be removed? Can the judges of Supreme Court can be removed? Yes, they can be removed. And there's a procedure that is given in the constitution, or rather than a detailed procedure, how they shall be removed. A process is given in the constitution. But however, the detailed procedure is not given in the constitution. The detailed procedure is to be made by way of a law. And such a law that has been made by the parliament is the Judges Enquiry Act 1968. But however, few information is given in the constitution itself. What is information? First of all, the constitution says as to what is the ground on which they can be removed. Now, what is the ground on which they can be removed? They can be removed on two grounds. One is proved misbehavior and incapacity. These are the only two grounds on which the judges of Supreme Court and High Court can be removed. Violation of constitution is for the president, office of profit is for the members of the parliament, not for the judges. So therefore, these two grounds on which they can be removed, and if at all they are to be removed, a motion has to be passed in both the houses of the parliament by special majority in both the houses, and this has to be passed in the same session, and subsequently it has to be approved by the President of India. Therefore, the removal authority when it comes to judges is only the President of India. Alright, but however, based on a motion that is passed by both houses of the parliament. How many of the above grounds are mentioned in the constitution for the removal of the judges of the Supreme Court and High Court? So, how many of the above grounds are mentioned in the constitution? So, proved misbehavior is there, incapacity is there. So, therefore, the answer is option B, that is 2 only. Alright, so just give me a moment. I will just see if any of the students are having any doubt quickly. I will try to take up the doubts also in the meantime. The idea is I want to keep the session as short as possible. So therefore, the students' time is not taken much. At the same time that most of your current affairs and your conventional areas in polity is also covered through this live session. So let me just see that if you have any questions, let me just check the comment box. Okay. So what is suo moto? I already said what is suo moto. Suo moto means on their own. That means there is nobody who has filed a case in the Supreme Court, but the Supreme Court itself has taken this particular case. That is basically what is called as suo moto. And against the order of the Lokpal, where the Lokpal order has said that the High Court judges would be a public servant under the Lokpal Act, which this matter, this order was automatically, Supreme Court itself has taken this particular order and stayed this particular order till the time the matter will be decided by the Supreme Court. Okay, so then there is a question, is the office of profit mentioned in the constitution or is that well defined? Okay, while the office of profit is mentioned in the constitution, but it is not defined in the constitution. In fact, this is again a very important area. If suppose a question comes, is office of profit defined in the constitution? It is not defined in the constitution. And there's one more question. I mean, not in the constitution, it was mentioned in the Representation of People Act 1951. Anyways, HRX Park has put a comment, but I do not know in which context you have put it. Otherwise, if you have any questions, you are free to do that. Okay, so let me just proceed further. Keeping in mind that I wanted to keep this session as short as possible. So if you need anything specifically, you can ask me the questions. Alright, so let us move to question number 22. Which article in the constitution allows the appointment of a retired judge of High Court as an ad hoc judge? So why this becomes very important? This becomes very important because recently the Supreme Court has come out with an order where it said that they wanted to reduce the arrears in the high courts. Today, one of the biggest issue with regard to the judiciary is the pendency of cases. And there are a lot of cases that is pending in the high courts. So therefore, a judgment was passed by the Supreme Court wherein it said that they have relaxed the conditions as to who can be appointed as the judges of the high courts in ad hoc basis. And normally, there is a particular provision in the constitution which already allows for it. But subsequent to that, the Supreme Court has also given certain guidelines as to who may be appointed as an ad hoc judge. But which article in the constitution? So therefore, the question may come, which article in the constitution allows someone to be appointed as what is called as an ad hoc judge? So it is article 224A of the constitution, very important. So sometimes questions from the appointment of judges do come. So here it is about the appointment of ad hoc judges. So as per article 224A of the constitution, the Chief Justice of the concerned High Court can call upon a retired judge of High Court, someone who is a retired judge of High Court, and ask him to work as a judge of a Supreme Court, judge of High Court on an ad hoc basis, on a temporary basis with the prior consent. So, but however, the consent of the president is important and also the consent of that particular judge, that is the retired judge. So, both their consent is very important. After taking their consent, on an ad hoc basis, a retired judge of High Court can be appointed to serve as a judge of High Court temporarily under article 224A of the constitution. But whatever be the allowances, salary of the ad hoc judge who is functioning, who is appointed to the High Court, will be decided by the President of India. But however, remember that the article is 244A. Article 214 is saying that every High Court shall have, every state shall have a High Court. And then article 217 is talking about the appointment of the regular judges of the High Court. It is not about the ad hoc judges. So therefore, do not get confused between article 217, article 214. So therefore, the answer in this particular case is option C. So please come to the next question. I will take up further questions after I complete 30 questions. Okay. So in the meantime, if you have any doubts, you can just put it in the comment box. What is rarest of rare doctrine? So anyways, this is not particularly related to any particular current affairs. But every now and then there is a lot of debate that is happening in our country with regard to what is called as capital punishment. Does the capital punishment need to be given? So does it have to be done away with? When I say capital punishment, means death punishment. And today the established principle in our country by the judiciary is when the capital punishment may be given, the capital punishment may be given only in the rarest of rare cases. Only in the rarest of rare cases, which is put forward by the Supreme Court in what is called as rarest of rare doctrine. In fact, why this came in the newspaper again? Because you know that there was a rape incident, unfortunately, that has happened in the West Bengal, the RG Kar hospital case. Now, the victim who was a doctor, and there is a lot of public sympathy for that particular victim. But after the trial is conducted, the convict has been given only a life imprisonment and not a capital punishment. Anyways, we are nobody to question the judiciary, but a lot of public criticism has come, and therefore a lot of news has come with regard to what is called as the capital punishment and the rarest of rare doctrine. So in this context, this news was there in the current affairs. So therefore it becomes very important. So what is the answer here? Circumstances under which the Supreme Court can use its extraordinary power under Article 142, no. Circumstances under which the President can refer a matter to the Supreme Court under Article 143, no. Exceptional circumstances, the court can provide death sentence to an accused. So this is the right answer. So the right answer is option C. So please come to the next question. Fact check unit of late in news is related to what? So very, very important. What is this fact check unit? In fact, this fact check unit is a unit that is to be established by the Government of India under what is called as the Information Technology Act. Under the Information Technology Act, the government has Information Technology Act 2000. They have made rules, and specifically they have made rules in 2023. And as per the rules, the government was enabled to establish what is called as fact check unit. And what shall be the role of this fact check unit? This fact check unit will check the contents that is posted in the social media. And if any of the content that is posted in the social media, and if this content is fake, false and misleading against the government, then such information may be flagged by the fact check unit, and then the fact check unit will take up this matter with the social media intermediary, and the social media intermediary has to remove these contents. And who is the social media intermediary? Say for example Facebook, WhatsApp, or for that matter YouTube. They are all social media intermediary. If any of the user is putting any information in this medium where it is against the government, which is misleading, not against the government, but if it is misleading against the government, fake, false against the government, then the fact check unit is going to monitor all these things. Now when this rule was brought in under the Information Technology Act, this rule was challenged in the Bombay High Court in a case which is called as Kunal Kamra case. And the Bombay High Court has said that the fact check unit that was brought in by the 2023 rules under the Information Technology Act is found to be violation of Article 19 of the Constitution. To be very specific, violation of Article 19 Clause 1 Subclause A, right to freedom of speech and expression, and Article 19 Clause 1 Subclause E, that is right to freedom of profession. And to that extent, this fact check unit under the Rule 2023 has been declared to be unconstitutional. So right now this is not possible, but this was there in the current affairs. So therefore you should have an idea of this. An entity to identify false, fake and misleading information about the government. So this is definitely true. A special agency under the Intelligence Bureau to verify the information related to national security, wrong. A part of Enforcement Directorate to take up cases related to serious money laundering cases, no. So therefore the right answer is what? The right answer is option A is the right answer. So please come to the next question, again part of the current affairs. Recently the Supreme Court of India has came out in one of the judgment wherein they said right to be protected against the effect of climate change is a fundamental right implied under Article 21 of the Constitution. In fact, in this question I have given only Article 21. In fact, the Supreme Court said right to be protected against the effect of climate change is implied both under Article 21 as well as Article 14 of the Constitution. But as per this particular question, Article 21 is the right case. 21 is the right answer. Alright, so we have almost completed halfway. I'll just quickly see if any of the other questions are there. So what are the other questions? Is there any other question? First question, sir, I was answered. Okay. I have a question. I have studied first 100 articles and I know about the state executives and about 200 article to 214, 200 of the Election Commission and all amendment acts of emergency. Is that enough, sir? Because I know in detail that these articles, but okay, so now have an understanding of one thing. 80% of your subject Indian polity is from 4 areas. For the students who may be appearing for the prelims, so 80% of your subject Indian polity is coming from 4 major areas. One is till the fundamental rights, or you can say up to directive principles of state policy or up to fundamental duties, that is still Article 51. So 4 to 5 questions or 5 to 6 questions will come from these areas. And then your next 2 to 3 questions are going to come from the executives, union and the state executives. And then another 3 to 4 or maybe even more than that, 4 to 5 questions are going to come from your legislature. That is, it includes both the parliament as well as the state legislature. And then remaining 1 or 2 questions are likely to come from your judiciary, that is high courts and the supreme courts in our country. And after that, the other areas are very simple areas. Center state relationship, probably 1 question. Panchayat, maybe 1 question. Constitutional bodies, maybe 1 question. So your 80 to 85% of the questions are covered from these areas also. So therefore, if you have covered till Article 225 or 230, where till judiciary is already covered, I think most of your thing is done. and you don't have to remember each and every article by heart, but you just should know the essence of these articles. So that is more than sufficient. Alright, so please come to question number 26. Consider the following statements. Interest of sovereignty and integrity of India, security of state, public order, friendly relations with foreign state. On which of the above grounds the government of India is empowered to block websites under the Information Technology Act 2000. So why this is important? Again, it is part of your current affairs. Recently, the government of India has blocked a particular website of a media, of a news channel, and then subsequently this news was reported in the newspaper. So can the government of India do so? Yes. The government of India is empowered under the Information Technology Act. And in fact, we know that the right to freedom of speech and expression under the constitution is not an absolute right. The right to freedom of speech and expression also includes what is called as right to freedom of the press. But this right to freedom of the press is not an absolute right. It can also be restricted by way of a law, but there shall be certain grounds on which they can be restricted, reasonably restricted. So what are the grounds on which they shall be restricted is given in the constitution itself. And based on those grounds, the Information Technology Act has been passed. Now, the Information Technology Act 2000 also allows the state to restrict the right to freedom of speech and expression on certain grounds. So, what are the grounds on which it can be done as per the Information Technology Act? Definitely on the grounds of protecting the interest of sovereignty and integrity of India, on the grounds of security of the state, on the grounds of public order, on the grounds that the friendly relation, ensuring the friendly relations with foreign states, and also on the grounds of defense of India, incitement to an offense. There are number of grounds that is given in the Information Technology Act. On these grounds, the state is very well empowered to restrict the right to freedom of speech and expression. So therefore, the answer in this particular case is all of the above. That is option D is the right answer. Please come to the next question. Consider the following statements regarding the position of law when it comes to position of law in our country related to minority educational institutions. Now, why this minority educational institution is very important? Because recently the Supreme Court of India came out a judgment with regard to the question of whether the Aligarh Muslim University is a minority institution in our country. Although the judgment that was recently passed did not say whether the Aligarh Muslim University is a minority education institution or not, but they have given a clarity on the thing that suppose if an educational institution is established by a minority and subsequently this educational institution is taken up by the government by way of a statute, and therefore by automatically the minority educational institution would not lose a status of a minority educational institution. To understand that, you should quickly know as to what is the history of Aligarh Muslim University. 1885 it was established by Anglo-Mohammedan Oriental College, and subsequent to that what has happened in 1920, the Aligarh Muslim, it was renamed as Aligarh Muslim University by way of a law. And then India became independent, India had its own constitution, and then it continued to be a state university. But then it still continued to be a minority educational institution. But in 1967, in a case which is called as Aziz Basha case, the Supreme Court categorically said that the moment the university is taken up by way of a statute, therefore it can no longer continue to be a minority educational institution. And recently that matter again was revisited by the Supreme Court in 2024, and the Supreme Court made it very clear, just because a minority education institution which is established by minority is now taken up by a way of a statute by the state, it will not lose up the minority education institution. To see whether it is a minority education institution or not, you should look into the genesis of the establishing that minority education institution, and who has given the donation, what was the purpose, what was the objective for which it is established. Just because it was taken up by a way of a statute, you cannot say that it is not a minority education institution. This was a judgment that was given by the Supreme Court. Therefore, you should be aware of Article 30 of the Constitution. Now, what is Article 30 of the Constitution is talking about? Article 30 of the Constitution is giving certain special privilege to the minorities. And what is a special privilege that is given to the minorities? To establish and to administer a minority education institution, and the minorities can be identified on two grounds, either on the grounds of religion or language. Now, with that you come here. The minority status granted to an educational institution under Article 30 of the Constitution, either on the grounds of religion or language. So, this is definitely true. There is only two grounds on which they can be established. An educational institution established by a minority community will not lose its identity once it is recognized through a statute. This is the part of the latest judgment that is given by the Supreme Court. So which of the statements given above is are correct? So the correct statement is both 1 and 2. So both the statements are correct. So please come to the next question. Question number 28. This is related to again right to property. Why this is very important? Right to property is very important because recently the Supreme Court has given certain procedural guidelines as to what is the way by which the private property of an individual can be compulsorily acquired by the state. We know that today the right to property in our country is guaranteed in the constitution under article 300A. So therefore under article 300A right to property is a constitutional right, but because it is protected by a way of a law, it is also considered to be what is called as a statutory right or a legal right. But however, the right to property, if at all to be taken away by the state compulsorily, they can take away it for public purpose. But even in that particular case, they have to follow a certain procedure. A 7 procedural guidelines has been given by the Supreme Court recently as to how the right to private property can be taken away. So how it can be taken away? Say for example, first of all, the individual should be given a notice. So yes, if at all the property of a private individual is taken away by the state, even if it is for public purpose, so first thing is what is called as right to notice. First the individual should be informed by the state. Right of the citizen to be heard. So the citizen should give his viewpoint as to whether he want to give the property or not to give the property. Right of the citizens to reasoned decision. It is also the right of the citizens to say no. He can give his reasoned decision as to whether he is okay with the acquisition of the property or not, but doesn't mean that the state cannot still do it. Right to fair compensation. Yes, if at all the property is still taken away by the state, the individual is also given the right to fair compensation, and the entire process has to be completed within a time bound manner. So in this way, the Supreme Court has given certain guidelines when it comes to the acquisition of private property in our country. So which of the above are the right of a person before his or her property is acquired by the state? So in fact, all these conditions are part of his right as per the Supreme Court guideline. So therefore, this is again very, very important. If a question comes in the examination, what is the position of right to property? If it is giving it as a constitutional right, that is true. But if the constitutional right is not given, instead of that they are given what is called as a statutory or a legal right, that is also true. And right to property today is available not only to the citizens, but it is also available to the aliens. So therefore, right to property is available to any person in India. That is a correct understanding you should have. In fact, earlier also asked in UPSC, again they can ask you in the examination. Alright, so please come to the next question, that is question number 29. In which of the following cases the Supreme Court brought in the 50% rule in reservation in public employment? Now why this is important? Recently the Patna High Court has struck down the reservation that was brought in by the state of Bihar, which is over and above 50%, and citing the earlier judgment which was given by the Supreme Court. So therefore you should also not only know that the Patna High Court has struck down the reservation that was given more than 50%, but in which Supreme Court case that this 50% rule was brought in. It was brought by a case which is called as the Indra Sani case in 1992. In fact, it was in the Indra Sani case the Supreme Court has innovated this 50% rule. So therefore the right answer is option A. Okay. So please come to question number 30. Recently the word general consent is often used in the news. What is does it refer to? Now what is this word general consent? Now this general consent is part of what is called as the Delhi Special Police Establishment Act. If you look into the Delhi Special Police Establishment Act 1946, under the Delhi Special Police Establishment Act 1946, the CBI, if at all they want to investigate outside the territory of National Capital Territory of Delhi, if they wanted to investigate with related to the prevention of corruption cases or any of the other cases outside the jurisdiction of Delhi in any of the state, therefore they have to take the permission of the concerned state. And this permission is given by the particular state in the form of what is called as general consent. If they are given for general consent, then for a fixed period of time, say 6 months, every time the CBI wanted to investigate on a particular case outside the territory of Delhi, they don't have to take the permission of the concerned state because the concerned state has given a general consent. But if the state withdraws a general consent, then on a case to case basis, every case probably the CBI has to take the permission from the concerned state. Now why this is again important, recently the state of Karnataka has withdrawn the general consent for CBI. The allegation that the state of Karnataka makes is that the CBI is misusing its power and it is politically targeting the opposition. So therefore the state of Karnataka has taken the general consent to the CBI. In fact, state of Karnataka is not the first state. Many states have done so and state of Karnataka has joined it. And therefore it was again in the newspaper. So therefore you should be aware of as to what is this word general consent refer to. It is a consent given by the individuals to the enforcement directorate officials to cooperate with investigation. No. Consent given by the state government to the CBI to investigate in the respective states. This is true. Consent given by terminally ill patients to carry out passive euthanasia. No, that is not the right answer. So therefore, the answer in this case is option B. Option B is the right answer. All right. So now we are moving to question number 31. I'll try to make the discussion as short as possible in the interest of the students. But however, let me see if there are any questions also. All right. So I think I have addressed almost all the questions. If you have any questions, you can just put it in the comment box. Okay. So I'll try to complete the discussion, say another 30 to 40 minutes at the max. But I'm sure that it is going to be very useful to the students for your last minute revision. Of course, who can extremely benefit is those who already revised or those who already know the basics, because this is primarily targeting for the students who are appearing for the prelims examination. For the students who wanted to prepare newly, there is another series that I have done, that is the Indian Polity series. And I would also say the students, if you have not gone through my current affairs series, you can just quickly go through it, because still there is time for your prelims examination. Hardly it will take 3 to 4 hours of your time if you sit and just watch in one single stretch. So therefore, the entire things will be very clear in your mind. Okay. So even if you can make 1 or 2 questions right by watching this particular series, that is a success to me and a success to you also. So please come to the next question, that is question number 31. 1 or 2 question means not just 1 or 2 questions, 1 or 2 questions in addition to what you will otherwise do. That is what is the understanding that with which I have said that. Come to the next question, question number 31. Consider the following. Now, why this question is relevant? This question is related to granting special category status to some of the states. In fact, after the 18th Lok Sabha elections, when the BJP formed the government, they formed government with the alliance of 2 major partners. One is JDU, another is the government, the Telugu Desam party in Andhra Pradesh and the JDU in Bihar. So therefore, both the states have been demanding what is called as a special category status. So that therefore, it was in the interest of the various political analysts, whether the government which is in coalition with these 2 parties, whether the government will give, the central government will give them the special category status. Now, what is a special category status? The special category status was introduced by the 5th Finance Commission. And the idea of giving special category status to some of the states is, once some of the states are given the special category status, they will get some special stimulus from the central government, special economic advantage from the central government. And in fact, one of the advantages in whichever scheme that is implemented by, whichever scheme that is brought in by the center towards a state, that is also called as the centrally sponsored scheme, that if at all a state is given a special category status, 90% of the fund will be given by the center itself. Only 10% of the fund has to be given by the states in implementation of that particular scheme. In otherwise, in the other states, it will be usually 50-50 sharing. So therefore, some benefits are given to the special category states. And normally the government has now got a criteria based on which a special category status may be given. And what are the criterias? In fact, whatever is given here, all the things are criteria. If it is a hilly state means then the developmental activities may get affected. Low population density or a sizable share of tribal population, more tribal population than less developmental area. Strategic locations along the international borders, it may be considered to be a special category states. Economic and infrastructural backwardness, non-viable nature of state finances. The state do not have much avenue to collect taxes. So these are all the grounds on which you can consider what is called as give a special category status. Today, if you see, in fact, all the northeastern states, and in addition to some of the northern states, when I say some of the northern states, Jammu and Kashmir, which is now not a state but a union territory. Earlier, when it was a state, it was given, and then you have Uttarakhand, you have Himachal Pradesh. Now, all these has been conferred the status of what is called as special category states. So, which of the above criteria are used by the center in granting it? In fact, the answer is all of the above. Again, I would say very, very important for your examination. So, please come to question number 32. So, recently the government constituted the 16th Finance Commission. Again, yes, the government in 2024 has constituted the 16th Finance Commission. And we know that the Finance Commission is a constitutional body appointed by the constituted by the President of India every 5 years. And the Finance Commission would consist of a chairperson and 4 other members. And the very important function of the Finance Commission is to determine as to how the revenue shall be distributed between the center and the states. This is in fact one of the important functions of the Finance Commission. They also recommend as to how the grantee aid shall be given to the states. They may also make recommendations as to how the states can improve upon their finances and any other matter that can be assigned by the president. But however, try to understand, while the constitution provides for the composition, but the constitution does not say as to what is the qualification of these members. The constitution has given this power to the parliament to determine the qualification of these members. Anyways, now let us try to understand further. Recently, the government of India constituted the 16th Finance Commission, whose recommendations will be valid for 5 years. This is true. Whenever the Finance Commission gives the recommendation, their recommendation will be valid for 5 years, starting 1st April 2026. That is also true. Till 31st March 2026, the recommendation given by the 15th Finance Commission will be in force. Starting 1st April 2026, which is the financial year 26-27, starting point of financial year 26-27, the recommendation that is given by the 16th Finance Commission will come into force. So this is definitely true. The Finance Commission is a constitutional body established under Article 148 of the Constitution. No, the Finance Commission is a constitutional body, that is true, but it is not established under Article 148 of the Constitution. It is established under Article 280 of the Constitution. It recommends how tax revenue collected by the central government should be distributed among the center and the states in the country. This is definitely true. So the Finance Commission not only recommends for the vertical distribution but also for the horizontal distribution. So therefore, statement 3 is right. So which of the statements given above are incorrect? So the incorrect thing is only statement 2. So therefore, the answer is option B. 2 only is the answer. Please come to the next question. Tax on land and buildings is an item in which list of the Constitution? So can anyone put the answers in the comment box? Let me see how many of the students are able to put the answers in the comment box. Tax on land and building is an item in the which list in the Constitution? In fact, in the Constitution 7th schedule, we have 3 lists: union list, state list and the concurrent list, and then we also have what is called as a residuary item. So what is the answer here? Is it an item in the state list, union list or the concurrent list? In fact, why I have brought in this particular question, recently the Supreme Court has come out with a judgment wherein it said that the states will have exclusive power to tax on the minerals that is explored in that particular state. If at all any mineral exploration is happening in a particular state, so who will have the power with regard to taxing those mineral exploration? It is exclusive and unlimited rights of the states. So therefore, the parliament cannot make a law, and by that law they can take away this particular power. So this is the judgment that is given by the Supreme Court. And what was the basis for which the Supreme Court gave this particular judgment? The Supreme Court gave this particular judgment because they see that look into item number 49 in the state list. Item number 49 in the state list talks about what is called as tax on land and buildings. Therefore, tax on land and buildings is an exclusive power which is given to the states, within which they can also tax the mineral that is explored in a particular state. So therefore, the answer is state list. Option B is the right answer. Therefore, in general, student doesn't have to remember all the items, but if at all something is there in the newspaper, then probably you can follow up those things. Then it may be relevant for your examination. Alright, so please come to the next question. As per the Chief Election Commissioner and the other election commissioners, Appointment, Conditions of Service and Term of Office Act 2023, the President would appoint the Chief Election Commissioner and the other election commissioners on the recommendation of a selection committee consisting of. Now, presently, this matter is sub judice, and the Supreme Court has taken up the review of this particular law. But however, the Supreme Court has not stayed the implementation of this particular law. They are just studying this particular law. The matter has been taken up by the court. Now, but there was a history behind this particular law. Initially, there was no select committee. All the election commissioners and the chief election commissioners were appointed by the president on the aid and advice of the Council of Ministers. But in the year 2023, a judgment was passed by the Supreme Court that henceforth any appointment will be made in order to ensure the free and fair election. The appointment that is done by the president with regard to the chief election commissioner or the other election commissioners shall be done on the basis of a select committee, and that select committee shall consist of the Prime Minister, the leader of opposition and the Chief Justice of India as per the direction that is given by the Supreme Court. But however, the Supreme Court said that the Parliament is free to make a law and they can change the composition of the select committee. And subsequently, within few months, the parliament has come out to this particular law. Now they have changed the composition of the select committee. Now, as per this law, who is part of the select committee? As per the law, the select committee includes the prime minister, the leader of opposition in the Lok Sabha, and the union cabinet minister to be nominated by the prime minister. So therefore, the right answer is option A. The other options are wrong as per the law. Now, what the petition is demanding? The petition is demanding that this law goes against the very essence of the Supreme Court, because the Supreme Court wanted to ensure a balance. There is one representative from the executive, one representative from the legislature, the prime minister from the executive, the leader of opposition from the legislature, and the chief justice of India from the judiciary. So therefore, they all will decide and appoint the recommended to the president. But the present law goes against the very essence of the judgment. So therefore, the law should be considered to be unconstitutional. Now, this matter is now taken up by the court. The court will come out to this judgment. But as students preparing for UPSC, you should know what is part of the law. So the answer is option A. Come to the next thing. The Law Commission of India is a. Now, why this particular question has been put in? Because recently the government has appointed the 23rd Law Commission. And the Law Commission in India is merely a body which is established by an executive order. That means it is neither a constitutional body, not established by the constitution, nor a statutory body established by way of a statute. So it is merely what? It is merely what is called as an executive body established by an executive resolution. So therefore, the answer is option C. Option C is the right answer. All right. So we have 15 more questions to go. I'll try to complete in half an hour. But before that, let me see if there's any question from your side that is not answered. I'll just quickly go through the questions. There's one question: can the Supreme Court review the judgment delivered under Article 142 of the Constitution? Yes, the Supreme Court also has got what is called as review powers. So even if the judgment is given by the Supreme Court by virtue of using its extraordinary power under Article 142, that judgment again can be reviewed by the Supreme Court. That power is there to the Supreme Court of India under Article 137 of the Constitution. They have what is called as review powers. All right. So please come to the question number 36. Consider the following statements. So this question is related to what is called as silence period. So what do you understand by silence period? Now, why this question is also important? Because this question is important because before the elections, if you understand the 18th Lok Sabha elections, before the last phase of the 18th Lok Sabha election, the Prime Minister Mr. Narendra Modi has gone for what is called as meditation, and that meditation was publicly displayed in all the news channels. And subsequently, there is a lot of opposition that has come, is that it is in violation of the Representation of People Act, because the experts pointed out and the other political parties also pointed out that it goes against the Representation of People Act, because as per the Representation of People Act, last 48 hours before the conclusion of the election, which includes the conclusion of the voting, it should be a silence period, and this is a silence period where there should be no political canvassing or any of the other political activities, including the social media platform. So this controversy was reported in the newspaper, and that is why you should also be aware of what is a silence period. Now let us try to understand through the questions. Silence period is used by the Election Commission of India to describe a 48-hour period during which the political parties and candidates are not allowed to campaign. This is definitely true. So last 48 hours, the political parties before the conclusion of the election, they shall not influence the voters, because that is the reason they maintain the silence period. Under section 126 of the Representation of People Act 1951, all election campaigning stops during the silence period that concludes with the end of voting. So this is also true. That means when the silence period, and how you calculate this 48 hours, right from the end of the voting hour and you go 48 hours backward. So that's basically what is called a silence period. Which of the statements given above are correct? So the right answer is option C. That is both the statements, both 1 and 2 are correct. Come to the next question. An accused person in jail cannot vote in elections but can contest elections. Say for example, a person is arrested by the police, but he is still an accused. He is not yet convicted in a court of law. A person in jail, or a person, let us assume, in police custody, but he is still an accused. Even if you are an accused, that is, you are not yet convicted in a court of law, even you are still an accused, but if you are in the jail or in police station, still you will not have the right to vote. Your right to vote is temporarily suspended. But will you have the right to contest election as long as you are convicted in a court of law? That is also true. So try to remember this. Somebody who is in jail, the right to vote is suspended temporarily. But will they have the right to contest election? Yes, they will still have the right to contest election. Because as per the law, a person who is convicted in a court of law shall be disqualified to contest election. But as per the law, a person who is in police custody, even if he is an accused, he is temporarily, his right to vote in the elections gets suspended. So therefore, it is very much possible a person may not exercise the right to vote, but still he will be able to contest the election. That is why sometimes the students ask me, how is it possible for a person in jail will be able to contest the election? A person in jail will be still able to contest the election as long as he is not yet convicted in a court of law. He is still an accused. He may be still an under trial. But in that case, he will not be allowed to vote in the elections, but he can still contest in the election. So this is very much possible. Section 62 of the Representation of People Act 1951 temporarily suspends the right to vote of an individual who is in jail or in police custody. But as per the Representation of People Act, an individual is still able to contest election as long as he is not convicted in a court of law, and that conviction only disqualifies him from contesting the election. Therefore, please come to this particular thing. So recently a lot of news has come regarding this. Come to the statement 1. An accused person in jail cannot vote in elections but can contest elections. So this is definitely true. An accused person will not be able to vote in the elections because his right to vote is temporarily suspended. But can he contest election? Yes, he can contest election as long as he is not convicted in a court of law. Because as per the section 8 of the Representation of People Act, when a person will not be allowed to contest election or disqualified from contesting election only when he is convicted in a court of law. So even after he is convicted in a court of law, the disqualification will come in. But can this disqualification period be reduced by the Election Commission of India? Yes. Normally, if anybody is convicted in a court of law for 2 or more years, the disqualification is for the term of the imprisonment, and then in addition to that 6 years. But can the 6 years term or the 6 years period, can it be reduced by the Election Commission of India? Yes, the Election Commission of India do have the power to reduce the term of disqualification under section 11 of the Representation of People Act 1951. So therefore, which of the statements given above are incorrect as per this particular question? So the Election Commission of India has a power to reduce the period of disqualification of a person to contest election. So the right answer is, which is incorrect, neither 1 nor 2. So because both the statements are correct. So the right answer is option D. Please come to question number 38. This is a question related to what is called as deregistration of political parties and derecognition of political parties. In fact, I have spoken to a number of students. They have a doubt with regard to what is called as deregistration and derecognition of political parties. And what is the power of political party today? Sorry, what is the power of the Election Commission of India today is only to derecognize a political party, not to deregister a political party. Now, why it is again in the current affairs? Because recently the Election Commission of India has written to the Law Ministry that to bring in changes in the Representation of People Act to give them the power to what is called as deregister a political party. Presently, as per the Representation of People Act 1951, under section 29A, to be very specific, of Representation of People Act, the Election Commission of India has a power to what is called as register a political party, but not to deregister a political party. Once a party is registered as a political party, then they try to exercise all the benefits as per the law. They may have certain tax exemptions, they may have certain other benefits also, which is there for a political party. But today the problem that the Election Commission of India is seeing, that many political parties are registering as a political party not with an intention of fighting the elections, but to take the benefit of the other areas. And therefore, it becomes a mockery in a democracy. So therefore, there are a lot of defunct political parties which are registered in the under the Representation of People Act. So therefore, the Election Commission of India has identified these political parties and they wanted to deregister these political parties. But however, they do not have the power as long as the law is changed. And that is why now they have written it to what is called as the Law Commission of written it to the Law Ministry to make changes in the Representation of People Act. But however, what is recognition of a political party? Do they have the power to do that? Yes. The Election Commission of India do have the power to derecognize a political party under the election under what is called as Election Symbols and Reservation Allotment Order 1968. So therefore, what is derecognition? Derecognition means you are only derecognizing the political party of its status. When I say of its status, say for example, you are derecognizing a political party from the status of a national party, or you are derecognizing a political party from the status of a state party, which they do get depending upon their performance in the elections. Once you derecognize them, still they are registered as a political party. That they are still a entity. Lawfully, they are a legal, they are a political party as a legal entity. But however, they may lose out on certain benefits, like benefits of the symbols that of their choice, or the having star campaigners in the elections. So these are all some benefits which are given to certain recognized party, which may be taken off, but otherwise they would still continue to be what is called as a political party. So again, I am repeating it. From the question we'll go that we'll go and just discuss the question. Section 29A of the Representation of People Act allows the Election Commission of India to register but no power to deregister a political party. This is definitely true. The Election Commission of India has a power to derecognize political party under the Election Symbols and Reservation Allotment Order 1968. This is also true. Which of the statements given above are correct? So the correct statement is option C, that is both 1 and 2. Both the statements are correct. Please come to the next thing. Recently in 2025, the 15th National Voter Day was celebrated by the government. So therefore, sometimes they can ask you such miscellaneous areas also. It's a part of elections and miscellaneous area. So when is the National Voter Day celebrated? The National Voter Day is celebrated on 25th of January, just one day before the commencement of the Constitution. That is on 26th January 1950. But the day is 25th January, and this year, that is 25th January 1950, marked the 15th year of National Voters Day. So therefore, the right answer here is option A. Okay, so this is a very factual information. So just try to remember this as well. So please come to the next question. Which one of the following constitutional amendment bill introduced in the parliament related to simultaneous election? You know that today a lot of proposal is happening with regard to what is called as simultaneous election. Now simultaneous election is an idea where the election to the Lok Sabha and to the various state legislature happen at the same time. Today it do not happen at the same time because after the commencement of the Constitution, there were early dissolution of some of the legislature. But again, this idea of simultaneous election is brought in, but to bring in the concept of simultaneous election, it requires certain constitutional amendments. And whether this is right or wrong may not be very important from the prelims point of view. That analysis may be important for your mains examination. But the prelims point of view, you should strictly know what is simultaneous election. And probably, does it require a constitutional amendment? Yes. And in order to bring in these amendments to the Constitution, already a constitutional amendment bill has been introduced. And what is the constitutional amendment bill that is introduced in the parliament with regard to simultaneous election? It is 129th constitutional amendment bill. So just try to remember this particular fact. The other things are not the right thing. So 129th constitutional amendment act, that is option A, is the right answer. Alright, so I'll try to quickly wrap up another 10 questions in just 15 minutes at the max. But if you have any questions, you can always reach out to me either through my Instagram account or through my Telegram channel. I'm sure that this session is going to be very helpful for your revision. And again, I am repeating it in case if you're not able to understand any of the areas, because considering the lack of time and I don't want to take too much time of the students, I'm keeping the discussion as short as possible, giving only the very relevant information. But if you need a broader explanation, you can go to my current affairs series and you can watch it. And in fact, there are only 7 to 8 sessions, 7 to 8 videos that I made. Everything is around 30 to 45 minutes. So roughly around 3 to 4 hours, you can cover all the things. In case, if you still feel that you need certain other explanation, you can watch that. Come to question number 41. Consider the following statements regarding the privilege motion in the parliament. Why privilege motion becomes important is again, especially against Mr. Amit Shah, who is the Home Minister of India. The opposition parties try to bring in what is called as a privilege motion. Now, what is this privilege motion? This motion can be brought against any member of parliament or against any minister. And what is the ground on which it can be brought in against any member of parliament or against any minister? If the members of the parliament feels that that particular member of parliament or the minister has breached the privileges of other members of the parliament. And what can be seen as breach of other members of the parliament? If a particular minister or a member of parliament is trying to mislead the other members of parliament, give false information, false narrative in the houses of the parliament, then it can be seen as a breach of privilege of the others. Now, in this case specifically, the allegation against Mr. Amit Shah is that Mr. Amit Shah has given wrong information related to the warning that has been given by the central government regarding the natural disaster that has happened in Wayanad. We know that few months back there was a landslide and unfortunate flooding event that has happened in Wayanad. So when this discussion was happening in the parliament, Mr. Amit Shah has said that the government of India has already given a red flag to the state of Kerala, but the opposition members said this was never correct in the when it comes to facts. So therefore, by making this statement, he is trying to mislead the other members of parliament. So therefore, he has breached the privilege, and they are trying to bring in what is called as a privilege motion. So therefore, it was there in the newspaper. Come to statement 1. The speaker or the chairman has a discretion to admit or to reject a privilege motion. So it has to be admitted by the speaker or the other presiding officer, chairman, and of course they do have what is called as a privilege. They do have the discretion in this regard. So definitely this is true. Misleading the other members of parliament may be a ground on which the privilege motion can be introduced against the members of parliament or a minister. So this is definitely true. This is a ground on which it can be introduced. Which of the statements given above are true? So the correct answer is both 1 and 2. That is option C is the right answer. Come to the next question. Panchayat Extension to Scheduled Areas Act 1996 formalized local government to which of the following areas? There are two important things. A lot of news articles came as to how the PESA Act has improved upon the life of people in the Schedule 5 areas, how the Forest Right Act has improved upon what is called as the community rights and the land rights of the tribal population living in the forest or the traditional forest dwellers. So lot of articles. So these are all general articles, miscellaneous areas, but you should have an idea about all those things. In fact, what is the objective of the PESA Act? If you see the very objective of the PESA Act, Panchayat Extension to Scheduled Areas Act 1996, it tried to formalize a system of Panchayat Raj administration in the Schedule 5 areas. Now you can ask me, sir, already the 73rd Constitutional Amendment Act is there. The 73rd Constitutional Amendment Act is trying to bring in a system of Panchayat only in the non-scheduled areas and those areas which are not covered in the Schedule 6 of the Constitution. So wherever the 73rd Constitutional Amendment Act will apply, it will apply throughout the territory of India, but not to the Schedule 5 areas and to the Schedule 6 areas. Therefore, to bring in a system of Panchayat to the Schedule 5 areas, that is wherever there is a area which can be declared as a scheduled area by the President of India, wherever there is a significant tribal population, that can be brought under the Schedule 5 areas. Today there are 10 states which are covered under the Schedule 5 areas, certain parts of those areas with significant tribal population. In those areas, to bring in a Panchayat Raj administration, a specific act was passed by the parliament, that is a Panchayat extension to the scheduled areas, empowering the Gram Sabha to protect the people in those areas. So to that extent, the Panchayat extension to scheduled areas 1996 formalized the system of local government in which one of the following areas? So the answer is it is Schedule 5 areas, not the Schedule 6 area, not both Schedule 5 and Schedule 6, and not none of the above. So therefore the right answer is option A. So the very object of Panchayat extension to Scheduled Areas Act or the PESA Act is to formalize a system of Panchayat Raj in the Schedule 5 areas. Then what is Schedule 6 areas? Schedule 6 areas is also to take care of the tribal people, but not in the areas which are covered in the Schedule 5, but it is specifically in 4 states. What are the states? Assam, Meghalaya, Tripura and Mizoram, in these 4 states. And if you ask me a question, is there a system of Panchayat Raj in the Schedule 6 areas? No. In the Schedule 6 areas, rather the administration is taken up by what is called as autonomous district councils. It is the autonomous district councils who will take up the administration. And in fact, if you see presently under the Schedule 6 of the Constitution, there are 10 autonomous districts in these 4 states. That is Assam, Meghalaya, Tripura and Mizoram. And in every autonomous district, there is an autonomous district council. And this district councils will have the legislative powers, they will have the financial powers, they will have the administrative powers, they do have certain judicial powers. Therefore, a lot of autonomy is given to the areas which is covered under the Schedule 6, but there is no system of what is called as Panchayat Raj in the Schedule 6 areas. So try to be very clear about all those things. Now, what is a Forest Right Act? If you ask me what is a Forest Right Act, the Forest Right Act is aimed to protect the rights of the forest dwelling community in our country. They may be scheduled tribes or they may be not a scheduled tribe, but who are traditional forest dwellers. So to identify those traditional forest dwellers and to confer them certain rights, that's basically what is called as the Forest Rights Act. And what type of right is given to them? Certain land rights. Up to 4 hectares of land is given to the traditional forest dwellers, and then certain community rights over the forest, certain minor forest produce over the forest. So all these rights are conferred upon to the traditional forest dwellers based on the Forest Right Act. So it is not related to bringing a system of Panchayat Raj institution. PESA is related to bringing a system of Panchayat Raj institution. So these two topics are very, very important. Again, many times has come in the newspaper. Okay. So now come to the next question. Recently, there was protest in the Union Territory of Ladakh for the inclusion of 6th schedule area. So this protest also happened in Ladakh. In fact, a lot of activists have participated in that. In this context, which of the following is true regarding the 6th schedule? What is the advantage a particular area may get if it is included in what is called as a 6th schedule area? So what is the advantage it may get? The 6th schedule area is applicable to what are officially called as tribal areas in the state of Assam, Meghalaya, Tripura and Mizoram. I said that the 6th schedule areas is only in these 4 states presently. If the other states are included or other union territories are to be included, it requires a constitutional amendment. So therefore, presently it is right. There are 10 such tribal areas present in these 4 states. This is also true. There are 10 such tribal districts. In all these districts, there is an autonomous district council. The autonomous district councils are formed by the in these tribal areas. These autonomous district councils shall consist of 30 members, where not more than 4 members are nominated by the governor of the state and the rest of them are elected by the people. This is also factually true. That means presently the schedule 6 areas is only in the state of Assam, Meghalaya, Tripura and Mizoram. And out of these 4 states, there are 10 autonomous districts. Every district will have an autonomous district council, and every autonomous district council will have 30 members, out of which 4 members are nominated by the governor of the state, remaining 26 are elected from the tribal people. And what is the function of this tribal autonomous district council? They have the law making powers. They can make laws in certain areas, which is given in the schedule 6 of the constitution. They can have certain financial powers, they have administrative powers, they also have certain judicial powers in related to areas like marriage, customs, inheritance of property. In these areas, they'll have certain judicial powers also. The ADC, the autonomous district councils, have the power to make laws with respect to use of management of land, regulate shifting cultivation, inheritance of property, marriage, divorce, social customs, etc. Now these areas are given in the schedule 6, and therefore they also have the power to make laws in these areas. So this is also true. And whatever they'll make, a law that they make, that has to be approved by the governor as per the schedule 6. But anyways, all the statement that is given is true here. So what is the answer? The answer is option D. That is, all of the above is the correct answer. So please come to the next question. Recently, the government of India accorded classical language status to 5 languages in India. Which of the languages is not one of them? Now, recently I am talking about in 2024, I think end, the government has accorded classical languages. I think November 2024, they have accorded certain languages the classical language status. So can you tell me what are the languages that has been given the classical language status presently? Even before these 5 languages, earlier 6 languages are given the classical language status. And if anyone know the answer, can you tell me what was the first language to be given the classical language status? And what was the second languages to be given the classical language status? So if you know that, you can also put it in the comment box. In fact, the first language is what? What is the second language? And then subsequently 6 languages were given the classical language status. But now the government has issued an order to give classical language status to another 5 languages in our country. And to that extent, they also relaxed the criteria for giving what is called as classical languages. Anyways, today, if you see, 5 languages were added to the status of classical language. And what are those languages? Bengali was definitely one among them. Prakrit is also there. Marathi is also there. In addition to that, Pali was there. And in addition to that, Assami language. So these 5 languages, Odia is not one among the 5 languages. In fact, Odia was already given the classical language status. So among the 6 languages that I said, Odia has already been given the classical language status. So the first language to be given the classical language status was Tamil. The second language that was to be given the classical language status was Sanskrit. And then subsequently other languages like Telugu, Kannada, Malayalam, Odia, all the languages has been given the classical language status. In addition to that, today 5 languages. Therefore, 11 languages in our country has been given the classical language status. May be important for the prelims examination. So just try to remember this. The next question is section 6A of the Citizenship Act. Why the section 6A of the Citizenship Act? What is the relevance of this? How it is related to the current affairs? Recently, the Supreme Court of India has upheld the validity of section 6A of the Citizenship Act. Now, what is the section 6A of the Citizenship Act? It is related to giving citizenship to certain people covered under the Assam Accord. You know that. Assam Accord was signed in 1985, especially to deal with who shall get citizenship and who shall not be given the citizenship, who shall be given the Indian citizenship, who shall be considered as an illegal migrant, those who have entered from Bangladesh into India. So, certain categories of people may be given the citizenship, the rest of them shall be identified and they shall be deported back to Bangladesh. So, the section 6A of the Citizenship Act was inserted in 1986, especially to give effect to what is called as the Assam Accord, which was signed by the Government of India, Government of Assam and certain political parties in Assam. So, therefore, try to understand this is basically what is section 6A, and that provision of section 6A was recently upheld by the Supreme Court of India. So, therefore, what is the answer here? Addressing the citizenship status of individuals who migrate to Assam from Bangladesh during specific periods. That is true. There are certain cut-off dates that is given in the section 6A. People who have migrated before 1st January 1966, they shall be given the citizenship. Migrated after 1st January 1966, but before 24th or before 25th of March 1971, they shall not be immediately given the citizenship, but shall be given citizenship after 10 years. But those who migrated after 24th March 1971, they shall not be given the citizenship. So, these are all certain cut-off dates that is given there. So, that is definitely the answer. Giving citizenship to illegal migrants from Pakistan, Afghanistan, Bangladesh. This is related to the Citizenship Act, Amendment Act 2019. This is not the answer. Suspension of overseas citizenship of India cardholder status on specific grounds. This is again not part of section 6A. So, therefore, the right answer is option A is the right answer. Come to the next question. Consider the following statements regarding the Armed Forces Special Powers Act. Now, why this question is also relevant? Because recently in the state of Manipur, in certain new areas, the Armed Forces Special Powers Act has been expanded. In fact, this Armed Forces Special Powers Act has a colonial legacy, and today wherever the Armed Forces Special Powers Act is invoked, the armed forces shall be given certain special powers. And what are the powers that may be given to the armed forces? That they can arrest individuals and they can seize the certain properties, and they can search and they can seize the materials, and in extreme cases they can also open fire. And for all these actions, a lot of immunity is given to the armed forces personnel. So, there is a lot of criticism against this Armed Forces Special Powers Act, but considering the security challenges in our country, the Armed Forces Special Powers Act continue to exist. But gradually, if you see, the government has been trying to use to restrict the use of this Armed Forces Special Powers Act. But however, you should understand, as per the Armed Forces Special Powers Act, the Armed Forces Special Powers Act can be invoked in a particular area only if that area is declared to be a disturbed area. Now, as per the section 3 of the Armed Forces Special Powers Act, when an area can be declared to be a disturbed area, an area can be declared to be a disturbed area when it is declared so by the governor of the concerned state or by the central government. So, with that, you just please come to this question. As per section 3 of the act, it empowers the governor of the state or the administrator of the union territory to declare an area to be a disturbed area or by the center. So, this is true. Presently, the Armed Forces Special Powers Act is not invoked in the state of Manipur. In fact, it was now extended in the state of Manipur. There are certain regions that has been brought within the Armed Forces Special Powers Act in the state of Manipur because of the tension that has been happening between two different tribal community in the state of Manipur. So, therefore, this is definitely a wrong statement. So, presently the Armed Forces Special Powers not invoked in the state of Manipur is wrong. But the question is, which of the statements given above are incorrect? So, the incorrect thing is only option B, that is 2 only is the right answer. So, please come to the next question. So, there are 4 more questions. Let me just quickly touch upon the doubts that you have got. Is there any other new doubt? Okay, first classical language is Tamil, second classical language is Sanskrit. Alright, I think most of your doubts has been clarified. Alright, so I'll just quickly cover up another 5 minutes. Let me try to wind up the questions. Okay. Which one of the following provisions in the constitution deals with respecting the national anthem? Now, why this question was, there was recent controversy that the governor of Tamil Nadu has left the session of Tamil Nadu legislature when he was there in the budget session in the Tamil Nadu legislature. He walked away in between without making his address, because similar to that of the president who makes a formal address in the houses of the parliament, the governor of every state also makes a formal address in the state legislature during the first session every year and also first session after the election to the state legislative assembly. And after the governor makes the address, then there is a motion of thanks that is also there in the state legislature as well. But what happened in the state legislature of Tamil Nadu is the governor has walked away without completing this. And the reason that the Rajya has given in state of Tamil Nadu is that in the Tamil Nadu government, in the state legislative assembly of Tamil Nadu, the national anthem was not sung initially. Instead of that, the Tamil Thaivat, a local tradition, has been followed. So this was the reason that was given by the Raj Bhavan. But whether it is right or wrong, I am not getting into that. But the question here is, what is the provision of constitution with regard to the national anthem? Where it is mentioned in the constitution, is there anything related to the respecting national anthem in the fundamental rights? No. In fact, the fundamental rights is for the citizens against the state. It does not entail any duty upon the citizens. Is it part of the directive principles? No. Is it part of all of the above? No. But there is a specific provision in the fundamental duty where we as a citizen shall respect the national anthem, the national flag. So, and the ideals which is related to the national freedom struggle. So, therefore, definitely it is part of the fundamental duties. So, therefore, the answer is option B here. So, you should be very clear about it. Now, please come to the next question. Question number 48. Again, this question is related to the three language formula controversy that is there. Again, the controversy is mainly between the central government and the state of Tamil Nadu. Now, when this three language formula, first we will have to understand when this three language formula was brought in 1968 for the first time as a part of what is called as a national education policy. Now, what is this three language formula is saying? The three language formula is saying that in any state for the purpose of educating the child, three languages has to be used. One is the regional language, another is English, and suppose if the state is a non-Hindi speaking state, so probably you can use what is called as Hindi as a third language. And if the state is a Hindi speaking state, then the regional language, and then you have English, and then preferably a South Indian language. So, therefore, the students will have knowledge of different languages, and a way by which the integrity can also be, the unity and integrity of India can also be ensured. This is what is the three language formula. But however, consistently in the state of Tamil Nadu, they were against this policy of three language formula, and they have been following what is called as a two language formula. And what is basically their regional language and the English language. And on top of this, the new education policy 2020, which has also brought in a similar three language formula, but the only thing is the experts say that the three language formula that is given in the national education policy is technically is much more liberal than that of the new education policy, the national education policy in 1968. Well, the national education policy mandate Hindi to be spoken in a non-Hindi language, non-Hindi state. That means regional language, English, and then if it is a non-Hindi speaking state, preferably it should be Hindi. But whereas in case of the new education policy 2020, it is not technically mandating the state, but it is only saying that you should follow three languages. Suppose your regional language, English, and then you teach one more language. So that is what it is saying. But however, the state of Tamil Nadu has been not implementing this three language formula. So there is a dispute that is going on between the center and the state of Tamil Nadu in this regard. Recently also I read somewhere in the newspaper that the Tamil Nadu government is going to make a petition to the Supreme Court against the three language formula. Anyways, it is for the government and for the judiciary to decide. But here you should have an understanding of what is this three language formula. Okay, so in this just come to the question here. Consider the following statements. First advocated as a part of new education policy 1968. As per this policy, Hindi speaking states were required to teach Hindi. As per this, Hindi speaking states were required to teach Hindi, English, and a modern Indian language, preferably a South Indian language. So Hindi speaking state means their regional language. Their mother tongue is Hindi, then English, and a modern Indian language, preferably a South Indian language. And a non-Hindi speaking state is expected to teach a local language, whatever may be the local language, Hindi and English. So this is definitely true. That is how the three language formula initially was brought in. The new education policy, however, is more flexible as it is technically does not impose a specific language on a specific state, but directs the states to adopt what is called as 3 language. So, this is also true. But the controversy is that the Tamil Nadu government is adamant on 2 language formula. So, which of the statements given above are true? So, both the statements are true. That is option C is the right answer. Now, please come to the next question. Which one of the following article in the constitution provides protection to the civil servant from arbitrary removal and dismissal? This is again very important. Now, why this is again very important? Recently, there was a incident where certain police officials has been removed from the Union Territory of Jammu and Kashmir by the Lieutenant Governor. And when the removal was done without a proper due process being followed. Because ultimately the Lieutenant Governor and the state authorities were convinced that the police officials were having certain links with certain terror organizations. So therefore, to conduct an inquiry, it would be risking the national security. So therefore, they were removed from the service. Now, Article 311 of the Constitution provides certain protection to the members of the services. Article 311 of the Constitution provides certain protection to the civil servants. And what is that protection? The protection is of twofold. One, that no member of the service, be it central service or the state service, shall be removed from the service by a subordinate authority to the appointing authority. That means if the president is appointing authority of the members in the central service, they can be removed only by the president, not by any subordinate authority. The governor who is appointing authority for the state government officials, it is the governor who can remove them, not by the subordinate authority. But even the appointing authority cannot remove them arbitrarily. That means even an appointing authority can remove them only after reasonable opportunity is given to them to explain their case. That means a proper inquiry has to be done and then only they can be removed. But this is a general rule. But this general rule also has got exceptions. What is the exception? The exception is that if the national security is at threat, or for certain reason you are not able to conduct an inquiry, even without an inquiry they can be removed. So, this was the provision that was used by the Lieutenant Governor of Jammu and Kashmir. But anyways, the general idea under Article 311 is to provide protection. But the incident that has happened in the current affairs is only an exception. So, which one of the following article is the Constitution provides protection to the civil servants from arbitrary removal or dismissal of the service? So, the right answer is Article 311. Article 309 gives the power to the central, the parliament to regulate the conditions of service of the central government employees and the state legislature to regulate the conditions of service of the state government employees. Article 310 says that the central government employees hold office during the pressure of the president. Article same 310 says that the state government officials hold office during the pressure of the governor. But however, Article 311 says that they shall not be removed arbitrarily. And Article 312 gives a power to the Parliament to create new All India service, provided a Rajya Sabha passes a resolution to that effect by special majority. So, therefore, try to remember all these articles. All these things can be asked in the examination. Come to the last question for the day, and again this is related to the current affairs. This is related to the current affairs because recently the third National Lok Adalat was established. And the historic thing about the third National Lok Adalat is that in one single day across the country 1 crore cases were resolved. 1 crore cases, which means 10 million, as per the newspaper report, 10 million cases were resolved. And how it is possible to resolve 10 million cases or 1 crore cases across the country in a single day? Because the way that the cases are resolved in the Lok Adalat. Because as you know that Lok Adalat is also a form of an alternate dispute resolution mechanism, or it is also called as basically ADR. Now, this system is much more flexible than resolving the cases in the court. Well, resolving the cases in the court is very, very rigid and it leads to win-lose situation. Whereas through Lok Adalat, there can be a win-win situation because the solution can be arrived at through what is called as compromise. Now, in fact, this Lok Adalat is established in our country based on a law which is called as Legal Services Authority Act. And this Legal Services Authority Act was passed by the Parliament to give effect to Article 39A in the Constitution. Article 39A is part of the Directive Principles of State Policy, where it says that there shall be free legal aid to the poor people. And in order to ensure this, the Legal Services Authority Act was passed. And this Legal Services Authority Act allows for establishment of what is called as Lok Adalat, which is also basically what is called as People's Court. And in the People's Court, they do not follow the strict rigid system as it is followed in the courts, but they follow simple method. Easily the cases can be resolved, which may also include what is called as compromise between the parties. But however, what type of cases that can be entertained in the Lok Adalat, there is a limitation. Only the cases which are compoundable in nature can be entertained in the Lok Adalat. The Lok Adalat can entertain both petty civil as well as criminal cases, petty criminal as well as civil cases, but the nature of the cases should be compoundable offence. Now, what is a compoundable offence? Compoundable offences are those offences where usually the punishment is less than 2 years, or they are all considered to be petty offences which are criminal in nature. So, normally in a Lok Adalat, the cases which are already pending in the court can also be entertained, or a fresh case even without going to the court, they can directly go to the Lok Adalat also. But however, the idea of Lok Adalat is to easily resolve the disputes and thereby reduce the pendency of cases in the judiciary as well. So, these are all the things that you will have to keep in your mind. So, with that we just come to the particular question. Lok Adalat, meaning People's Court, is an alternative dispute resolution mechanism in India established under the Legal Services Authority Act. That is true. It provides for an amicable settlement of disputes pending in courts or at a pre-litigation stage through mutual consent of the parties. So, whatever case already pending in the court, so they can move an application and they can withdraw the case from the court and go to Lok Adalat. Or two parties can directly go to the Lok Adalat also. So, both are possible. Lok Adalat aim to make justice accessible, affordable, speedy, especially for the weaker sections of the society. This is also true. It makes the administration of justice more simpler, easier, faster, especially to the weaker sections who may not wait for a long period of time to get justice in a court of law. So, which of the statements given above are correct? All the above. Option D is the right answer. So, with that we are coming to the discussion of the 50 most important topics. I have covered already these 50 topics in the current affairs series. As I promised, I wanted to do the questions on these particular topics. So, I thought that it was better to do as a live session so that I can take up the doubts from the students as well. So, what I will do is I will also share the PDF of this. I will share the link of the entire document. If you want, you can just have it for your revision, and I will also provide the answer key. So, both the things I will provide it in the description below once the session is over. And then on top of that, if you have any doubts, you can also go through the current affairs session that I have already done. And on top of that, if you have any queries also, you can reach out to me through my Instagram account or Telegram account on these questions. All right. So, let me just quickly see if there are any doubts from any of the students. Let me just quickly see. Okay. Okay, so I think that I have answered to almost all the questions. So, if you have any further questions, you can definitely reach out to me. All right. So, with that, I'll wind up the session for today. So, before I wind up the session, I would convey my best wishes to all the students appearing for the Prelims 2025. I'll try to do a session also as to what are the do's and don'ts before you go to the Prelims examination, because apart from all the preparation that you have made, it is also important that you remain very stable at the time of examination, and certain things to avoid before the examination, at the time of examination, and certain do's that you should keep in your mind. So, I'll try to do that. So, with that, I'll wind up the session for today, and thank you very much for watching this particular live session. And please do reach out to me in case if you have any queries, and do recommend this video to any of your friends who may be preparing for this examination, because it may also be really helpful to them. Thank you very much and all the very best.